Before we begin, I'd like to clarify that the information presented in this podcast is for general informational purposes only and does not constitute legal, financial, professional, and compliance advice. Listeners must engage qualified professionals to understand how SEC's cyber disclosure rules applies to their specific circumstances. The views expressed here are based on our interpretation of the rules as of the recording date. Welcome to Ctrl+Alt+Comply, where regulation meets reality and risk becomes actionable. Today, we are diving into SEC's cyber disclosure rule with a special focus on Form 8K filings. What they entail, challenges companies face in compliance, and some common misconceptions. Generally speaking, Form 8K filing is used to announce major events to shareholders and investors. Information about mergers and acquisition, changes in management and operational developments, and last but not least, material cybersecurity events are some types of information disclosed on Form 8K. It's interesting to note that Form 8K is not a scheduled filing. It is filed on an as-needed basis, triggered by events. If you were to look at some of the Form 8K filings available on SEC's website, you will notice that in some of those forms of filings, companies have disclosed events such as stock buyback, dividend payout, changes to their board of directors, changes to their company leadership. The situation is different for everybody. You must consult your professional to understand if your situation warrants an 8K filing. Form 8K has 3 pillars. First pillar is the cyber incident disclosure. On Form 8K, there is a section or item number 1.05, which must be filed within 4 days of determining an incident is material. The second pillar of Form 8K is governance and strategy. Companies must disclose board oversight and cyber risk management as part of their 10K filings, which is an annual filing. The third pillar is ongoing updates. Now, what do I mean by this? For those of those colleagues in incident response and investigation, digital forensic investigations, know that 4 days is generally not enough time to determine if an incident, especially one that's widespread, is material enough. Meaning that does it affect the company so much that we need to go in front of national TV, run ads in the newspaper, have our lawyers come up and tell the people, do a damage control, go to the regulators, or not one SEC, but any other regulator, and report that incident? sometimes it's not enough to do that. Now, if you were to go through the 8K filings on SEC and look up a few companies that were breached recently in the past, say, 2, 3, 4 years, you will notice that in some of these companies that shall not be named, mentioned in their initial 8K filing that yes, we have discovered a breach or an incident in our environment affecting whatever asset. However, we have not made a materiality assessment, or a decision has not been made because the investigation is ongoing. They did that, filed the report. Great, they comply with the law. Now, this is where the third pillar comes in, which is ongoing update. So let's say during the course of the investigation, they discover that they do not have enough information to determine that this incident is still material, and let's say it's been 4 weeks. So what they can do is file an amendment to their initial report. And I've read some of these reports where they said, all right, yes, pursuant to our filing on XYZ date, we want to notify that, and I'm paraphrasing this, that we have not made a decision yet. We have not arrived at a decision because the investigation is ongoing. Plain and simple. Or in one other case, they said, yes, we did an investigation, and as a result of the investigation, we found out that there was no material harm to our company or to our customers. Now that is allowed under law. This is where the continuous ongoing updates come into play. Whenever you discover a pertinent or material information about an existing filing, you are supposed to declare that. Now let's assume that if you discover a material, let's just assume that you did make an assessment initially that there was a material, that you had a material breach. File the report within the 4 business days SLA that you have with the regulator. And then you discover that there was something else, that there was collateral damage that you did not know about in your initial filing. That becomes material importance to the regulator and warrants disclosure. Could warrant disclosure, pardon me. In that case, you can file an amendment to your existing 8K filing with the notes as determined by your compliance and legal experts. The question that comes up more frequently than not is, what is materiality? How is it pertinent to cybersecurity event? That question is a very loaded question and warrants a separate session. SEC mandates that we report material cybersecurity events within 4 business days. New York Department of Financial Services under Part 500 mandates that we report material cybersecurity events within 72 hours. None of the regulators have stated what they mean by materiality. We will discuss that in a separate call, but for SEC's purpose, we can assume that materiality is a collection of facts and circumstances and anything else that a reasonable investor will consider while making investment decisions. At this point, you should have made a determination as to whether you are in scope for SEC's cyber security disclosure rule, what business is in scope for that, what business activities are in scope, etc., etc. And of course, you must have also determined what constitutes a material cyber event. I know we are going to discuss the topic of materiality in a separate session, but you should have made some headway on that already. Now let's say you are ready to file your Form 8K for a cyber event or incident disclosure within the time period prescribed. Section 1.05 must state the nature, scope, and timing of the incident. Next, it must state the material impact or the reasonably likely impact to business operations, finances, customers, etc. There is no need to mention technical details, but you should have some information about remediation that's ongoing or has been conducted. Now, this is where some companies fall short. We will discuss that in the next segment. But I would strongly caution against understating or misrepresenting this information in your filing, and especially under section 1.05, which deals with material cyber events, incidents. But at the same time, you have to be careful on what you state. You don't need technical jargon here. This is not the place to showcase your technical prowess, but you have to relate your technical prowess with business impact, because that's ultimately the audience. What do I mean by the nature of the incident? In 1.05, item 1.05, there is no place for you or the company to showcase its technical prowess. Why? Because the audience is your average investor or the public at large. So when I say be specific but not technical, then let's assume you had a breach of your customer's information. In your Form 8K filing, you're not going to write, we had a breach, this happened, and then that happened, and then let's say they came in through the firewall, they bypassed the firewall, they bypassed our MFA, and they got in and did something, exfiltrated using a DNS tunnel. None of that. We don't need all that information. Those details are not necessary here. What you could instead, when I say be specific, do not just then you can say, all right, I'm going to exclude all of these technical details, and instead I'm just going to mention we experienced an advanced cyber incident. Yes, you are specific, you are not technical, but it is too vague. A reasonable investor can look at this and say, what are you hiding? Ambiguity creates confusion and creates doubts and casts doubts onto your reputation. When you are ambiguous, it indicates that you're one, dodging the question, secondly, you're not being honest and forthcoming, which is the intent of this filing. Instead, you could say something like, there was an unauthorized access of our customer databases via an exploited third-party vulnerability. What you should also mention, of course, is attack vectors. How did it happen? Was it a ransomware? Was it a phishing, smishing, spear phishing? How did this incident happen, if you know it? So now you could also say something like, let's just assume you know it, you could say, we know that ransomware was deployed via a successful phishing campaign targeting an unsuspecting employee. So that is more forthcoming and honest than saying we had an advanced cyber attack. There are several hurdles that companies face to meet these tight deadlines imposed by the Securities Exchange Commission, SEC. First is timeliness versus accuracy. 4 days is not enough to gather all the forensic evidence and make an informed decision. Second hurdle is coordinating the various teams, IT teams, executives, legal, compliance, etc., to ensure that we have everybody on the same page, everybody understands what the company is ready to do, which is disclose a material cyber event. The next is, again, the magic question, the materiality judgment calls. Over here, I would say one of the biggest fears that companies have is the fear of under-disclosing. It's okay to over-disclose. Under-disclosure is what gets companies and executives into trouble. The third hurdle is ongoing reporting, especially in an incident that is very active in its remediation and investigation. There may be a need to constantly and proactively update Form 8K filing with an amendment. Now, one of the ways that companies can go about this is to have a pre-drafted 8K language in their incident response plans and have that language or incident response plan tested annually at least, or maybe more frequently if the risk profile does mandate that. And part of the test should be a mock exercise to do an 8K filing. In this segment, we are going to go over some of the myths and misconceptions on Form 8K filing. What are things that people get wrong about Form 8K filing most of the time? And of course, cyber disclosures. The first myth and misconception is that breaches with financial losses are considered material. Not true. Breaches that can lead to significant reputation damage or operational failures may also trigger Form 8K filing. The second myth is that disclosure of the Form 8K filing will trigger lawsuits. While that may be true, it is possible, but not filing or filing late or even lying or not being truthful in your disclosure carries far greater risk. SEC has set a precedence on this, on the non-disclosure or falsification of the disclosure when they sued SolarWinds and Uber's CISO Timothy Brown. The latter lawsuit was of course dismissed last year by a New York federal judge. But yes, it does carry a risk. However, the risk is not as great as if you were to lie or not disclose within the required time period. The third is that technical details are required to do the filing. Well, remember what I said earlier. The idea behind Form 8K filing is to provide investors and the like with full disclosure so that they can make an informed decision whether or not to invest. What you should do in your filing is, again, like I said in one of the earlier segments, that it's not a place to show your technical prowess. Rather, you need to explain it in business terms. What did this breach do? What was the result? What was the outcome? What have you done after that? Let's say you had a breach again of the customer databases. You had 1 million PII records that were disclosed. What did you do after that? Did you fix the vulnerability? Did you attempt to get the information back, or did you put in credit monitoring and other services for the customers? That's one other thing that people will look for, and not technical details as to what patch you released and what OS was impacted, etc., etc.
We have seen today SEC cyber disclosure rules, especially the Form 8K requirements, aren't just about checking a box. They are about transparency, accountability, and protecting investors in an era where cyber risks are unavoidable. To recap, file timely, accurate 8K with nature, scope, and timing. Avoid pitfalls. Misrepresentation or delays can trigger lawsuits or SEC action. Prepare now. Test your incident response plans and materiality framework. Treat cyber disclosures like financial reporting, rigorous, documented, and investor-focused, and remember, good and accurate disclosure is not just compliance, it is a competitive advantage in building trust. please share this episode with their compliance teams and other team members. Follow us on LinkedIn, Twitter, Instagram, and TikTok. Until next time, stay vigilant, stay compliant, and we'll see you in the next episode.